Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.
Mr. Duterte is suspected of the crimes against humanity of murder and attempted murder. These were allegedly committed in the context of the War on Drugs campaign in the Philippines between the 1st of November 2011 and the 16th of March 2019. Count 1, murders in or around Davao City during his mayoral period allegedly carried out by the Davao Death Squad. Count 2, murders of alleged high-value targets during his presidential period. Count 3, murders and attempted murders during barangay clearance operations during his presidential period. After the defense raised questions about Mr. Duterte's fitness to take part in proceedings, the judges ordered a report of 3 independent experts who conducted a medical examination of Mr. Duterte. The judges reviewed this report along with relevant legal principles and circumstances of the case, and they found Mr. Duterte fit to take part in proceedings. This means he is able to understand the charges against him, the evidence, and the purpose and possible consequences of the pretrial proceedings. He is also able to instruct his defense counsel. Victims are at the heart of ICC proceedings. They have several rights before the court, including to participate in proceedings and, after a trial, if a person is found guilty, to apply for reparations. In the Duterte case, the judges have authorized a number of victims to participate in proceedings and have appointed one team of common legal representatives to represent them. The team of lawyers will make oral submissions at the hearing, voicing the victims' views and concerns before the judges.
Good morning, London. Good evening, Philippines, and to our viewers around the world, good day. Today, February 23rd, 2026, marks a watershed moment in Philippine history. After months of legal tug-of-war, the International Criminal Court in The Hague officially opens the confirmation of charges hearing against former President Rodrigo Duterte. But before the first gavel falls, we need to understand what is actually at stake. Is this the trial? Not yet. It is the litmus test for the prosecution's evidence. I'm Rose Eclarinal, and this is our TFCN Special Primer. One of the biggest questions we've heard since Duterte's arrest in March 2025 is, why is he there if the Philippines has already left the ICC? To understand the legal why, let's look at this explainer on the Rome Statute.
Does the ICC have jurisdiction in the situation in the Philippines?
The Philippines, a sovereign state, had decided to join the international treaty, which is the ICC Rome Statute. It's the treaty that created the International Criminal Court. This is a sovereign decision by the Philippines. And also the Philippines, later on, decided in a sovereign way to withdraw from the ICC Rome Statute. It's also a sovereign decision that we have to respect. We hope that in the future, Philippines and all states that are currently not parties to the Rome Statute would be again in this joint group of states committed for a global fight against impunity and for justice for the victims. But in the meantime, we fully respect the sovereignty of each state to decide to join, to remain a state party, or to withdraw as a state party from the ICC Rome Statute. However, when withdrawing from international treaty, there are certain elements that have to be put in place. And essentially that the Rome Statute itself indicates that, for example, the withdrawal will only be effective 1 year after the deposit of the withdrawal instruments of the state of Philippines in this case. But also the ICC judges have clearly indicated that the Rome Statute include the simple idea that during the time that a state was party to the Rome Statute, crimes committed on its territories or by its citizens are under the ICC jurisdiction, meaning under the court's authority to investigate and eventually to prosecute potential perpetrators of these crimes. This authority does not stop when there is a withdrawal. The withdrawal is only for the future, meaning that after the withdrawal becomes effective, if there are crimes committed on the territories or by the citizens of the state that withdrew, they would not be under ICC jurisdiction. But crimes that were under the ICC jurisdiction because the state was a state party, they remain under ICC jurisdiction, even if we can trigger this jurisdiction by an investigation after the withdrawal. So actually the ICC retains jurisdiction over the crimes that were under its jurisdiction during the time that the state was a state party. And this jurisdiction can be used, triggered, exercised at a later stage, because it's important to highlight that the crimes under the ICC jurisdiction, so war crimes, crimes against humanity, genocide, are so serious, so grave, that they cannot be kind of stopped because of time passing. There is no status of limitation for them. So even after 10 or 20 or even more years, they were under ICC jurisdiction, they remain under the ICC jurisdiction and can be prosecuted if all the legal conditions are, of course, met. So in this case, this is why the ICC has jurisdiction over crimes that were committed on the territories or by citizens of the Philippines at the time that the Philippines was a state party, but does not have this jurisdiction for potential crimes that may occur after the withdrawal becomes effective.
While the jurisdiction is clear to the courtroom itself will look a bit different today. Former President Duterte has officially waived his right to attend, meaning his chair will be empty. So, who will be doing the talking? Let's meet the cast of characters.
All right, so let's get right into it. Today, we're taking a close look at a really significant legal event at the International Criminal Court. We're going to break down who's who in the confirmation of charges hearing for the case against the former Philippine President Rodrigo Duterte. The hearing kicks off with this really striking image, or, well, the lack of one. The person at the center of it all, the accused, isn't there, and that's a huge part of this story. But as this opening line tells us, his absence doesn't actually stop anything. So that brings up a big question, right? How can a court hearing like this possibly work without the main suspect even in the room?
Okay, so before we meet all the players, let's just be super clear on what this hearing is. This is not the big final trial. You can think of it more like a critical checkpoint. The judges are basically looking at the prosecution and asking, all right, show us what you've got. Is your evidence strong enough to even justify a full-blown trial? It's kind of like a legal filter to make sure the case has some real weight to it.
So, who gets to make that massive decision? Let's meet the first group, the folks with all the power here, Pretrial Chamber I. These are the 3 judges who are going to hear all the arguments and make the final call. It sounds simple, but this is their one and only job at this stage, and it is a huge one. I mean, their decision literally determines the entire future of this case against the former president. No pressure, right? And what's really amazing is just the sheer level of experience on this panel. You've got the presiding judge Ulia Motok from Romania, who is a top expert in international law. Then there's Judge Rain Alapini Gansu from Benin, not only a human rights specialist, but also the ICC's second vice president. And to round it out, you have Judge Socorro Flores Liera from Mexico. Get this, she was actually one of the original negotiators for the Rome Statute, the very document that created the ICC in the first place. So yeah, this is a seriously heavyweight bench.
Okay, now let's flip over to the other side of the courtroom, the office of the prosecutor. These are the people who brought the case forward, and now they have to prove it was worth it.
This right here, this is the specific legal bar they have to clear. It's not beyond a reasonable doubt. That comes later in a potential trial. For now, they just need to convince the judges that there are, and I'm quoting the legal term, substantial grounds to believe that these alleged crimes happened. So it all boils down to the strength of their initial evidence.
Leading this effort is Deputy Prosecutor Mame Mandaya Niang. His job is to connect all the dots for the judges. He has to lay out what they're calling a common plan. This is a really key idea in international law. The argument is that these weren't just random acts, but part of a coordinated policy that involves the former president and 8 other named individuals.
And this really sets up the central conflict of the whole hearing, doesn't it? On one side, the prosecution is trying to build a case strong enough to move forward, and on the other, the defense's job is to poke holes in it, to question every part of its foundation. So let's talk about that defense. Because even though the suspect's chair is empty, there is absolutely a robust legal challenge happening on his behalf.
The defense team is really running a 2-pronged strategy here. First, they're going to go after the evidence itself, arguing it's just not enough. But second, and this is a big one, they're going to challenge the court's very authority, its jurisdiction. They're basically asking, does this court even have the right to hear this case? It's a common and pretty powerful move in international law.
The man spearheading this challenge is Nicholas Kaufman, a British-Israeli lawyer. His role is to represent the former president's interests, making sure that even though he's not there, his side of the argument and every possible legal objection gets heard loud and clear by those judges.
But this case isn't just about judges, prosecutors, and defense lawyers. A core part of the ICC's mission revolves around the victims. So, let's take a look at who's speaking for them. 539. I want you to just let that number sink in for a second. This isn't just some statistic. It represents 539 individual people whose stories were heard and who've now been officially authorized by the court to be a part of these proceedings. It's just a powerful reminder of the very real human scale of this case.
And they are not voiceless. They have a really dedicated legal team. This includes Filipino lawyers Joel Bution and Gilbert Andres from Center Law, which is so important for having that local perspective. And they're joined by Paulina Masada, who's from the ICC's own Office of Public Counsel for Victims, an entire office created specifically to make sure victims' interests are always represented.
So, when you put all of these pieces together, the judges, the prosecution, the defense, and the lawyers for the victims, you start to see this whole complex system. It's a complete machine, really, designed to pursue justice, even when the circumstances are, pretty extraordinary. And that brings us right back to where we started, doesn't it? While the suspect's chair remains empty, the legal machinery of the ICC is at full capacity. The main takeaway here is pretty clear. The system is designed to keep moving. It doesn't just grind to a halt because of one empty chair. Honestly, this case is a huge test for the International Criminal Court, and it leaves all of us with a really critical question to think about. When the machinery of justice moves on without the person at the center of it all, what does that truly mean for the future of accountability on the world stage?
This hearing was originally supposed to happen 5 months ago, back in September 2025. What caused the delay? It was a battle over health, memory, and the definition of fitness to stand trial. Our next report looks back at the defense's claim that the former president was medically unfit to face the court.
September 23, 2025, araw na dapat magsimula ang confirmation of charges hearing para sa alleged crimes against humanity sa International Criminal Court laban sa dating Pangulong Rodrigo Duterte. Ipinagpaliban ito ng Pre-Trial Chamber 1 upang bigyan ng mga judge ng oras na timbangin ang kahilingan ng depensa na ihinto ang mga proceedings dahil may problema umano sa kalusugan ang 80 anyos na si Duterte. Ang kumpirmasyon ng mga reklamo na kung tawagin ay confirmation of charges ay isang bahagi ng proseso ng pre-trial sa ICC. Kung makukumpirma ito, tutuloy na ang kaso sa trial. 3 counts ng crimes against humanity resulting to murders ang isinulong ng prosecution. May kinalaman ito sa war on drugs ni Duterte noong siya ay mayor ng Davao mula 2013 hanggang 2016 at bilang Pangulo mula 2016 hanggang 2022. Ayon sa depensa, unfit to stand trial si Duterte dahil limitado na ang kakayanan nito na makapagbigay ng tamang instruksyon sa mga abogado at hindi na niya maalala ang mga bagay at oras, gayon din ang limitadong kapasidad sa complex reasoning. Parehong umaasa mga miyembro ng pamilya Duterte at mga pamilya ng mga biktima ng war on drugs na magkaroon ito ng resolusyon. Ang isa ay humihiling na palayain ng dating Pangulo sa lalong madaling panahon sa pamamagitan ng tinatawag na interim release.
We are so sad that it's better to that the process should be faster than this. 6 months na siya nasa loob, diba? 6 months. So, I think pwede lang sana. He would be released, different release, granted sa kanya. That's okay na sa amin. And besides, Rodrigo said, now he is accepting everything. Whatever comes to him, he is accepting. I think, okay na daw siya yan. Ganun sabi niya. Parang may acceptance na siya.
Ang isa naman ay humihiling na kumpirmahin ang mga kaso upang siya ay makaharap sa paglilitis. Para sa abogadong si Cristina Conti, na kumakatawan sa maraming pamilya ng mga biktima, hanggang ngayon ay walang kasiguraduhan kung at kailan maibibigay ang hustisya para sa kanila.
Yung isang parang hinagpis pa nga nung kapamilya na, tingnan mo, very stark na nakakabisita, yung mga namatayan na, very stark na kay Duterte may nakakapag-update. Ito yung nangyari sa kanya, parang halos ginawa na nga nilang parang kubaw lang yung kubaw kaya po, yung dahig. Every week, every other week, may bisita siya, may kapamilya. Samantalang sila, yung mga namatayan, saan mo dadalawin? Hindi pa nga nakaburol sa maayos na puntod. Yung mga dating namang nakulong, ang iniisip nila, nung panahon nga namin, hirap na hirap kaming bisitahin at wala kaming pera na mag-supply doon sa nakakulong. Kaya, bittersweet para sa kanila na, ayan, nakakulong na, pero naalala nila yung kapamilya nila.
Sa kabila ng postponement ng confirmation of charges noong September 23, ang mga taga-suporta ni Duterte at mga grupo na humihiling ng accountability ay nagtipon sa iba't ibang bahagi ng dahig upang i-drumbeat ang mga panawagan.
Andito tayo ngayon sa tinatawag nating Land Van Gorbachev and Ronald Reagan. At dito naman sa kabila ay makikita natin ang tinatawag na Homo Monument. At madalas, dito nagtitipon-tipon ang mga taga-suporta ni dating Pangulong Duterte. Lalo na kung marami ang pupunta. At dito sa lugar na to, nagsiset up sila ng stage. At dito naman, gaya ng mga nakarang araw, ay naglagay sila ng public exhibit sa buhay ni dating Pangulong Duterte.
Kung walang malaking pagtitipon, bumibisita sa harap ng ICC Detention Center ang mga supporters sa isang bahagi ng kalsada na binansagan nilang Duterte Street. Samantala, ang mga grupong humihingi ng pananagutan ay nagtipon sa harap ng ICC at Peace Palace, ang upuan ng Permanent Court of Arbitration na nagdesisyon na pabor sa Pilipinas sa kaso laban sa China sa West Philippine Sea noong 2016. Karamihan sa kanila ay mula sa mga human rights groups. mga migranteng aktivista, abogado, social worker at mga estudyante. Bukod sa accountability ni Duterte sa ICC, panawagan din ng grupong ito ang pananagutan sa korupsyon sa bansa. Ang magkabilang panig ay kumakatuan din sa magkaibang anyo ng Filipino diaspora sa ibang bansa. Magkaiba sila ng background at paniniwala. Ang isa na naniniwala sa personality politics at ang isa pa sa mga isyu ng lipunan. Ang nasa pagitan ng mga magkasalungat na grupong ito ay ang gusali, hindi kalayuan sa Scheveningen Beach ng The Hague, ang ICC.
Mahigit 6 na buwan na simula ng maaresto at dalhin dito sa Netherlands si dating Pangulong Rodrigo Duterte. At dito sa glass building na ito, ang seat ng International Criminal Court, gaganapin ang mga proceedings sa reklamong alleged crimes against humanity laban sa kanya.
Ang nasa pagitan ng mga magkasalungat na grupong ito ay ang gusali, hindi kalayuan sa Scheveningen Beach ng The Hague, ang ICC, kung saan isasagawa ang paglilitis kung ito ay matutuloy. Para sa mga biktima, ang ICC ang court of last resort dahil sa paniniwalang walang matatamong hustisya sa Pilipinas. Para naman sa mga kritiko ng ICC, ang pag-aresto kay Duterte ay may halong politika.
The key messages, I would say, is to trust that there are independent and impartial judges who would apply the law, who would ensure the fairness of the proceedings, the full respect of the rights of everyone, of the defense, of the victims as well, and will judge only based on the rule of law, but also on the evidence that is available to them.
Ang ICC ay binuo upang tugunan ng pinakamatinding krimen na banta sa international peace at justice. Opisyal na sinimulan noong 2002, nabuo ito bilang tugon kasunod ng Nuremberg at Tokyo trials. At kalaunan ay mga ad hoc tribunals para sa genocide at war crimes sa Yugoslavia at Rwanda.
Andito tayo ngayon sa harap ng The Hague Penitentiary kung saan nandito din ang ICC Detention Center at dito nga nakadetine si dating Pangulong Rodrigo Duterte. Ang malaking tanong, ano na matapos maglabas ang pre-trial chamber ng limited postponement ng confirmation of charges. At ito ay hindi natin alam kung kailan matutuloy. Pero sa mga taga-suporta ni dating Pangulong Rodrigo Duterte, patuloy silang pupunta dito para ipakita ang kanilang suporta. At para naman sa nananawagan ng accountability, patuloy pa rin ang kanilang pagsasaliwalat ng kanilang mga damdamin. At kami naman po dito sa TFCN ay patuloy na tututok hanggang sa huli. Kasama si Raquel Salinel ng TFCN Dubai. Ako po si Jofel Tesorio mula dito sa Scheveningen, The Hague, Netherlands para sa The Filipino Correspondent Network.
In a redacted 16-page document released just last week, ICC prosecutors officially named 8 individuals. They believe they were the gears in this machine. They're not just bystanders. The ICC calls them co-perpetrators. The list includes sitting senators Ronaldo Bato de la Rosa and Senator Bongo. It names former Justice Secretary Vitaliano Aguirre II and former NBI Director Dante Hiran. Also cited are former PNP chiefs Oscar Albayalde, Vicente Danao, and the late Camilo Cascolan, alongside former PIDEA chief Isidro La Peña. Today, we'll look at how the prosecution intends to prove that these 8 men didn't just follow orders. They shared a singular violent vision to neutralize suspected criminals. Our special report on the common plan and the burden of imputed guilt begins now.
So here's a really tough question. When leaders are in charge during mass atrocities, how do you actually hold them responsible for crimes they didn't, personally commit with their own hands? It's a huge, complex problem, and that's exactly what we're going to dive into. Just take a look at this. This image, it captures just one moment from the Philippines' war on drugs that kicked off back in mid-2016. And the tragic thing is, this was a reality that played out night after night, on street after street.
And the scale? Well, it's just staggering. In only 7 months, we're talking from July 2016 to January 2017, official police stats showed 7,025 people were killed. I mean, do the math. That's an average of 34 people killed every single day. And that led Amnesty International, after a detailed investigation, to this one stark conclusion. Their report found that this wasn't just some general war on drugs. No, it was a war on a very specific group of people. And who were they? Well, according to that same report, the vast majority of the victims were from the country's poorest, most marginalized city neighborhoods. The violence wasn't random at all. It was targeted. Okay, so this brings up a huge problem for international law, right? The people actually pulling the triggers, they're usually not the ones who made the policy. So how do you connect the dots? How do you bridge that gap and make sure the people at the very top are held accountable? Well, it turns out international courts have come up with some very specific legal tools to solve this exact problem. The goal, to go after the commanders, the architects of the plan, not just the foot soldiers on the ground. And to help us understand all this, we're going to lean on two key sources for this explainer. First, that Amnesty International report, which gives us the real-world context. And second, a really in-depth academic paper from the University of Galway that breaks down the legal ideas used to pin down this kind of high-level responsibility. The main idea here is something called imputed criminal liability. Sounds complicated, but it's basically this. Responsibility for a crime can be imputed or, assigned to someone who didn't physically do it themselves. And there are two key legal tools that make this happen. Okay, first up is something called joint criminal enterprise, or JCE for short. Honestly, the best way to think about it is like a conspiracy theory, but on steroids. It means if you join a criminal plan, you can be on the hook for other crimes that happen, even if you didn't plan them, as long as they were a natural and foreseeable consequence of the original plan. And that phrase right there, natural and foreseeable, that's the game changer. It casts a really wide net. The second big one is called superior responsibility. This is all about commanders and leaders. Basically, a leader can be found criminally responsible for what their subordinates do if they knew or should have known what was going on and didn't do anything to stop or punish it. That little phrase, should have known, is absolutely critical. It means a prosecutor doesn't need to find a smoking gun, like a direct written order. So this really clears it up, doesn't it? On one hand, you've got direct responsibility, that's the person who actually did the thing, and on the other, imputed responsibility, that's the leader who made it possible, either by being part of the plan or by just failing to stop their own people. Now, you can probably guess that prosecutors at international courts love these ideas. They're incredibly powerful tools. For example, joint criminal enterprise was a huge deal at the Tribunal for the former Yugoslavia. It was used to convict leaders for the Srebrenica massacre. Why? Because these tools work. They let the courts go after the big fish, even when there's no perfect paper trail of direct orders. And here's why they're so effective. They fundamentally change the standard of proof. A prosecutor doesn't always have to prove that a leader intended for every single crime to happen. Instead, they can focus on what was foreseeable or what a commander should have known. And that makes getting a conviction a whole lot easier. But this leads to a much bigger question. Is getting a conviction the only goal here? When we talk about international justice, is that where the story ends? Or is there something more we're trying to achieve? Because here's the twist. Let's dig into the critique, which comes from that Galway paper. It argues that these super useful legal tools, well, they have a major, almost paradoxical downside, one that could actually undermine the whole point of having a trial in the first place. And look, this isn't some new debate. This quote here is from a dissenting opinion all the way back in the famous Yamashita case, right after World War II. It just nails the central risk here. If a trial is seen as unfair, it doesn't lead to healing. It just creates more anger and gets in the way of reconciliation. See, for people who champion international justice, these trials are about so much more than just one guilty or not guilty verdict. They're about the big picture, making peace,
stopping future crimes, giving victims some sense of justice, and this is a big one, creating an accurate, official, historical record of what actually happened.
And this is where we get to the heart of the critique from the Galway paper. The argument is that when you stretch the rules of guilt like this, when you lower the bar for intent and knowledge, it starts to look less like holding someone accountable for what they personally did and a lot more like simple guilt by association.
And that's not just some abstract legal argument. That perception has very real consequences. A conviction that feels unfair, or like it was won on a legal trick, can completely backfire. It can fuel resentment, help people deny what happened, and actually get in the way of those bigger goals of peace and reconciliation.
So what we're left with is this massive paradox, this real dilemma. On one side, there's this desperate, urgent need to hold leaders accountable for absolutely horrific, widespread crimes. But on the other side, there's this core legal principle we hold dear, that guilt has to be personal, it has to be individual.
And that leaves us with the final, big question to think about. In the race to get justice for the many, what's the price we pay for stretching the definition of guilt for the powerful few? How far can we bend those rules before we break the very idea of justice for trying to build?
As we saw in the report, the judges ultimately ruled on January 26 that Mr. Duterte is fit to participate. Despite his absence today, his legal team, led by Nicholas Kaufman, will be there to challenge every piece of evidence presented by the prosecution. The goal for the next 4 days, to see if there are substantial grounds to move to a full trial. TFCN will be here every step of the way with live updates and expert analysis. Don't miss our live coverage starting today, February 23 at 5 p.m. Manila time, coinciding with 10 a.m. start in The Hague. I'm Rose Eclarinal, and this is TFCN, your news, your story, your network.